the purpose of this presentation is not to totally terrify you, but I think that not a week goes by where we don't hear about some new major cybersecurity event in the news and the wide-ranging implications of that. So the purpose of this presentation is not to go over how to protect your systems, how to prevent a cybersecurity incident, because we like to say in this space, it's not a matter of if you will be breached, but how many times you will be breached. And so this is really to talk about some proactive things that you can do now to make that incident response process go by a little bit smoother, but also what to expect from a regulatory standpoint. So the breach happened, can't go back and change that, but how can we make sure our response process is smooth, and what can we do now to prepare for potential regulatory investigations? So I'll start off by just giving you a little bit of a background about why we as attorneys have to be really, really considerate about these types of things, because it affects not just our organization's IT department, but we as lawyers are going to play a big role in the incident response process. So a 2022 survey said that CLOs ranked cybersecurity as the #1 concern. Tired of regulation compliance, but cybersecurity is a lot more exciting. And there are a lot of reasons for that, right? So the first is that there is a significant financial impact to organizations that have experienced a cybersecurity event. And oftentimes when we engage with our clients and the chief legal officer, general counsel says, we're concerned about a ransom payment. We want to move this along because this is going to be a large financial hit to our company. It's a lot more than just that, right? So of course, you have the ransom payment, which can be millions of dollars, but also downtime. Your organization, if you can't use your systems, if you can't operate, that can be millions of dollars a day just in operational damages. Obviously, there is a ransom payment. There's legal fees for responding to the incident. There's potential litigation. So this is a huge financial impact to your organization, and this is why attorneys are now becoming, taking a more proactive role in the incident response process, because a lot of times the C-suite is going to look to us to minimize this impact. So this is just an overview of the most common types of incidents that we see. The first three are probably, I would say, the most common. So you have ransomware. That can be with or without encryption, right? So pre-Colonial Pipeline, which you probably heard of in the news, which kind of was a turning point in the way that threat actors work, the most typical scenario is someone from your organization logs on, a system is down, they can't access, whether it's payroll, whether it's payment card processing, whatever it is, something happened where your systems are no longer operational. You find a ransom note that says, we stole your data, we encrypted your systems, engage with us on this chat link and we'll talk about what you can do. And oftentimes those threat actors will say, all right, we can decrypt your systems, we'll give you back your data, you pay us $10 million. There are reasons why some organizations would choose to or not to engage with that threat actor. Oftentimes, it really depends upon whether or not they need a decryption tool to get their systems back to an operational standard. We're going to talk about that a little bit more later, but that was kind of the big, major incident type that we would see. Post-Colonial Pipeline, threat actors realized that shutting down critical infrastructure probably wasn't good for business, because it was all over the media, FBI was really active, and they realized, this isn't really great for us, this is going to make us more likely to get caught, let's not go that route. So what we're seeing a lot of now is extortion without the ransomware. So that basically means that they'll contact you, say, hey, we stole all your data. You might be operational, so it's not as likely to be a major news situation, which kind of protects the threat actors a little bit. But what they say is, all right, we have all your HR files that have all of your employee social security information. We have your patient health records. We have, whatever it is, you need to pay us to get that back. We're seeing a lot of that now. Not to say that we're not seeing situations where systems are also encrypted, but that's kind of been a new trend. And the third most common one is a business email compromise. So we see this all the time. An employee gets an email that says, hey, Susie sent you a DocuSign. You need to open this and sign it right away. They click on it. actually it's a credential harvester and they now have this employee's access credentials, they get into your systems that way. It's usually not as big of an impact as a ransomware incident, but it is a very, very easy way for threat actors to get into your systems. A lot of times, we've seen the gamut of how creative these phishing emails can be, but that is a big one. And we're also seeing now a lot of MFA fatigue. So what that is depending on how your organization does two-factor authentication, you might get a push notification to your phone, for example, and when you get, a bunch of them in rapid excess at 2 a.m. and you roll over and say, leave me alone, and you just press it, that's really a threat actor trying to get in. You've now given them access to your VPN. They're now in your system. A lot of times, too, we'll have clients say, I thought it was my spouse. They just wanted to get on my computer to do something. I didn't realize. And they get in that way. So just a couple of things to look out for. This is a typical timeline of cyber incident response. Notice here, it doesn't have, it's not a timeline in terms of days or months or years, I'm sorry to say, because every incident, of course, is different. But this just gives you an overview of the 4 kind of main phases of incident response. So, the very first one, the threat assessment and containment. Oh my gosh, our systems are down, or someone says they have our data, or, someone posted online and now, we found out this way. It's really going to be a lot of what happened, what data is involved, how do we get it back, do we negotiate with a threat actor? This gets very complicated because your IT teams are going to be scrambling, trying to investigate and figure out what happened. And of course, we as lawyers are going to be getting hundreds of questions, whether it's from the board, whether it's from regulators. And so it's a fine dynamic between us on the legal side, that's kind of the middleman between the rest of the organization, external parties, and our IT teams. So we always like to say, be very patient with them, be very nice to them. They're stressed out, they have not slept. But this is kind of the initial phase of that response process. Then let's say you figure out, okay, this threat actor did steal a bunch of data. Whether you get it back from them or whether you have forensic evidence to suggest what that universe of data is, now there's an e-discovery process, right? Because your legal obligations are going to depend on what that data is. And that might be because it's personal data, so there's state breach laws that apply. It might be because there's business sensitive data and you have contracts with your customers or vendors that say if confidential information is accessed, you have to notify us. Depending on what industry you're in, federal laws can apply. So you have to see what that data is to figure out what your legal obligations are. That's that process. Then, of course, notification and response. So you notify individuals, regulators, customers, what have you, depending on what that data is. 9 times out of 10, when you notify regulators, particularly federal regulators, they will come back with an RFI. And then you finally have the closure phase, which is we often will do a lessons learned. So sit down, whether it's with IT, C-suite, employees, figure out, what happened, how can we fix it, what did we learn from this process, and what are steps that we can take to make sure this does not happen again. All right, so I won't go into too many details about this slide because, again, I think the bulk of this presentation and why you guys are all here and interested in this is to learn more about, the regulatory investigation process and kind of the aftermath of this. But just so you have a bit more background, I think, ransomware, again, is the biggest one. Ransomware as a service, it's exactly what it sounds like. So you will have multiple threat actors at play. One of them essentially figures out how to get into your system, and then they sell that access to a different threat actor who will then actually exfiltrate the data and exploit your company. They operate as a business. It is wild. I mean, they have helplines, they have websites, they conduct marketing campaigns. It is truly wild, but they do it. It's extremely popular. Black Boston now is the biggest one. They've kind of taken over the Conti group. And of course, nation-state intrusions are always around. Those are always popular, depending on, what industry you're in. And then vendor incidents too, we have a lot of our clients have not had an incident, but their vendor has. And their vendor has, whether one popular one that we had recently was an auditor. So they had, collected a lot of this client was in the healthcare space, they had a lot of their client patient-related information. So that was a HIPAA-related situation, so they were a business associate, so that implicated a lot of HIPAA response requirements. You might see too law firms. Not Norton Rose Fulbright, of course, but other law firms, they have your data, and depending on why you engage them, that is quite sensitive, right? And so it's not only your organization that, of course, you have to be nervous about, but who are you giving your data to? And do you even know how many other third-party vendors have your sensitive information? And are they safeguarding it appropriately? All right, so now we're getting to the good stuff. So now that you're sufficiently terrified, we're going to move into the legal and regulatory environment. So this is kind of where we as lawyers get to shine, because we can now advise the rest of our organization on what they have to do following a security incident. So there are federal and state laws, of course, as you know. All 50 states plus DC, Puerto Rico have data breach notification statutes. What's really fun is that each state has its own definition of a breach of personal information, of when you have to notify, whether you have to notify an attorney general or another regulator. And these statutes are triggered based on the residency of the data subject. So let's say your company operates in Texas, but you have customers nationwide. You don't only have to notify the Texas Attorney General or Texas residents. Because the information applies to individuals of other states, you have to notify them, see if that state notification statute is triggered. And so oftentimes for companies that operate in multiple states, you're dealing with many, many regulators, not just in the state where you primarily operate. A few states now are moving into more of a reasonable security standard, so kind of an overall cybersecurity statute. So California, of course, is the big one. Colorado now, Virginia, a couple of other states as well. We're hoping at some point there will be a federal one, but as of now, it's just really exciting that we have to think about 50 states and all of their different statutes. Of course, reasonable security is not defined, and so what you as an organization consider reasonable to safeguard your data is going to depend on a lot of different things. How big you are, how much money you have, the type of data that you process. GDPR is the European statute. Of course, if you are a US company, but you are still targeting data of EU residents, so that could be because you advertise in the EU or because you have some employees there, that will be triggered as well. Then you have the FTC Act, which they can enforce data breach incidents and response under Section 5 of the FTC Act, because they have said that failure to safeguard information is in of itself an unfair, deceptive trade practice. If you are in the healthcare space, the FTC also has the health breach notification rule, HIPAA, of course. If you are in the financial industry, there's GLBA. So the takeaway from this slide is that there are a lot of different laws at play. I can't think of a single incident that I've worked on where there's only really one regulator involved. And they all have different timelines, right? So for example, if you have an incident that has European impact, there's a 72-hour requirement in Europe. At that point, you don't really know what's happened, right? Your IT team is still scrambling. You might not even know who the threat actor is, how they got in, what data is involved. In the EU, also, you have to designate a lead supervisory authority. So that's kind of like your at-home regulator. And they're always going to disagree. So you might decide, all right, Germany is our lead supervisory authority. That's where we're at home in the EU. But France is going to say, actually, we think we are also your lead. So you have to report to us as well. So this is all going on in a very tight time frame, which is really fun. All right, so kind of touched on the state breach laws already. Again, different personal information, one state might not be personal information in another. For example, Texas says that health information is considered personal information, even if it's not covered by HIPAA. New York does not. So it really depends on where these individuals reside, which is part of that e-discovery process. And part of what makes it take so long is you might have spreadsheets full of people's names and social security numbers or driver's license number or passport number, whatever it is. But now you have to figure out where do they live, because passport number is not personal information in every state. So are they employees? Does your HR department have all of this data? Are they customers? How do we find out who these people are, where they live? Because we need that to figure out what laws apply. All right, so breach happened, you figured out who the data subjects are, you figure out what laws apply. Now what happens? Some states, so for example, Indiana is really, really active. They will usually send a very similar set of questions following every incident within about a week or so. HHS almost always responds if you are required to notify under HIPAA. And this is what we're seeing in terms of that regulator activity. So they give you really tight timeframes. We can usually get an extension, but oftentimes, they'll ask you really technical questions that as an attorney, you're not going to be able to answer, right? It's going to be about your systems. It's going to be about how you operate. It's going to be about different firewalls and tools that you're really going to need to reach out to your other teams, whether it's IT, whether it's an external forensic investigator, to be able to answer that question. And they are going to be competing timelines, right? So you're going to have, and I touched on this a little bit before, but you might have, the Texas Attorney General asking you for these questions in a week, and, the California Attorney General is asking you kind of similar questions, but they're a little bit different also. In this meantime, your IT teams are still working on containment and remediation sometimes, right? So there's a lot going on. And so what we like to caution our clients is that from the beginning, have a very thoroughly document remediation steps, the technical steps. You want to have evidence of things. So by that I mean, screenshots of your firewall tools. Basically everything has to be documented, and we can get into a little bit of the privilege concerns there, because that's something that, everyone is obviously concerned about, and for good reason. But the key there is that when you are getting a ton of RFIs from different regulators and they all have competing deadlines, you don't have the time to be fighting with your IT team to say, I need this information now, because they're still working on fixing this matter in the first place and making sure that your systems are operational and that everything's remediated. So it's kind of a proactive approach, even though you might not know from the beginning if you even have to notify any regulators, is let's at least prepare a timeline, whether it's a chronology or, just kind of an external facing report that we feel comfortable giving them, because they're going to ask. So these are some of the most common questions that we get from regulators. Again, a lot of them are going to be very technical, and a lot of them are going to focus on that specific incident, but not all of them, because regulators, particularly the federal regulators, are going to see this as an opportunity for them to audit kind of your entire cybersecurity incident response posture. So you might have an incident that occurred because a threat actor exploited maybe a vulnerability in your VPN device that wasn't even, we call that a 0-day vulnerability, when that wasn't even disclosed. There's really nothing you could have done to prevent that. Vulnerability existed, the threat actor got in. The regulators are still going to say, okay, well, tell me about your employee training. Tell me about phishing training. Tell me about, your data governance. So knowing this ahead of time, and oftentimes lawyers are kind of surprised about, I didn't realize how much I needed to know about our technical infrastructure. That's a very IT-focused thing, but you're going to have to be able to speak on it, right? So knowing a lot of this ahead of time, or at the very least knowing who to talk to. So who is the person that knows where your HR data is stored? Are benefits stored in the same places that payroll, tax information is stored? You want to know that, because you don't want to be figuring this out after you have an incident and you're trying to figure out where the data lives, what was protecting it, right? Information governance, so retention schedules is a really big thing that regulators are focused on now. And so by that I mean, they want to know that you, A, have a legitimate business reason for maintaining this information, and B, that it's maintained in a manner that makes sense, right? So by that I mean, obviously, you have a legitimate business reason as a company for retaining your employee SSNs, benefits information, all of that really sensitive stuff, right? But you need that as a business. Where the regulators are going to get concerned, however, is when someone from accounting, for whatever reason, has to download a spreadsheet of employees' tax information from whatever reporting requirement, and they download it to their desktop and it stays there. Or they send it in an email and it's not password protected. So it's not always that you have this information. Of course, they get frustrated when they see really, really old information that you don't actually have a business need for. But it's very justifiable why you have a lot of the information that you do, but are you instructing employees to maintain that information in a manner that is compliant? So you shouldn't be emailing around your colleagues' social security numbers. You shouldn't be having this on your desktop. If you need it, there are circumstances you need to download this stuff, delete it. Try to limit the places where this information is being dispersed throughout your organization. And again, oftentimes our clients are like, but we're the legal office. We don't deal with this. But it's important for the attorneys to be able to know, what policies do you have in place? Who is in charge of this? What are the annual assessments doing? Because attorneys are now being relied upon to be the kind of front line in cybersecurity response where we might not previously have had to a couple years ago. So attorneys need to be more and more involved in that process. All right, so again, without repeating what the last slide said, these are the regulator priorities that we often see. So, first and foremost, the regulators want to know that you responded appropriately. So you had the incident. Every company has it. They're not going to necessarily fault that for you unless it was something like so blatantly you should have caught this and you ignored a ton of these alerts and, something like that. But did you actually say, okay, we undertook efforts to figure out what the data was involved and to notify people? Or did you kind of wait a little bit and maybe delay notification for whatever reason? Did you not notify a regulator when you probably should have? The worst thing that happens is when you get a regulator saying, because they all talk to each other, right? So you don't want the Massachusetts Attorney General to send you an email that says, hey, I know you had a data breach because, you told the Delaware Attorney General. Why didn't you tell us? And that answer might be because you didn't have any Massachusetts impact, so you're not required to tell them. But you don't want to get into a situation where it's like, oh, well, we kind of only really told the Texas AG, we didn't really tell anyone else, and that's when it gets into trouble. So first and foremost, they want to know that you really did your due diligence to figure out what happened. Did that entail negotiating with a threat actor or did it not? Did you work with the FBI or did you not? Did you send out notifications? And a big thing that companies struggle with, and I alluded to this a little bit more in the beginning, is that you might not have the addresses for all these people. They might, if they're not your employees, they might be customers, they might be, you might be the vendor in this situation and you don't have contact information for these people. If their social security numbers are involved, there are ways that we can find those addresses, or you can work with other third parties to find that. But sometimes you just can't do it, right? Sometimes it's just not practical. So there are methods of substitute notice that oftentimes our clients aren't thrilled about because it might involve posting a notice on your website and posting something in the media, which no one wants to do. But the alternative is the regulator saying, hey, we know this happened and you never told these people. You just kind of buried your head in the sand. So again, just making sure you did what you were supposed to do. How did you remediate the incident? How quickly did you allocate enough resources to do that? These are just kind of the most common questions that we see from regulators. Of course, California is the only state right now that has a private right of action currently in effect. More are coming. But again, they define the private right of action involves reasonable security practices. So if you are a victim of a security incident, by virtue of the fact that a company has a breach, does that mean that they did not have reasonable security practices? You now have a private right of action against this company, and these damages can be extremely, extremely high. I also did want to touch on BIPA. It's not necessarily strictly a breach statute. BIPA is an Illinois Biometric Protection or Privacy Act. It applies to the collection and processing of biometrics, so fingerprints, iris scans, that type of thing. This was the first jury award in a major privacy case, and the the penalty was $228 million. And since this award came out, the Illinois Supreme Court had said in another case that it's not, so let's say, this is often in the employment context, where let's say your employees clock in with their fingerprint every day. That's how they get into your building. It's not how many employees you have, but it's how many times you have collected that fingerprint. So if you are a company that operates in Illinois, or you have Illinois employees, and you have 100 employees in Illinois that clock into work Monday through Friday for the last year, that's a lot of damages. And the Illinois Supreme Court pretty much went as far as saying that the statute was challenged as being unconstitutional because it's going to put companies out of business. And they basically said, well, then comply with the statute. So did just want to raise that because litigation in the BIPA context is extremely hot right now. So if you are engaged in any sort of biometrics collection, or you think you might be, come and chat, because this one is getting a lot of attention right now. All right. So privilege. This is always something that comes up in this context because, a couple minutes ago I said you want to document everything, you want to be able to tell regulators what happened, but you also don't want to necessarily have to make this information discoverable should litigation arise after the incident. So these are a couple of do's and don'ts. So whenever our clients they realize that they've been hit with a security incident, the first thing we always advise is engage external counsel, because the courts have said that responding to a data breach is a business function. So even though you might be working for the general counsel, you're an attorney, not everything that you do might be considered privileged, because responding to a breach, getting your systems back, informing the FBI, all of those conversations, the courts might say that serves a business function, and you do not want to be in a position where now all of the drafts that you've had your eyes on, everything that you've done, all of your work product is now discoverable. So we always recommend engaging external counsel. We also always recommend engaging a third-party forensics firm to actually do the investigation, they can help you recover, they can help with remediation. And what they do is they will draft a report of exactly what happened. And we always recommend that they have an external report and an internal report. So that external report is going to be what you give to your customers, what you give to regulators, and that pretty much just has, an overview of what happened, does not include system names, does not include any recommendations, anything about remediation, but just a very basic, this is what happened, because you also don't want to be in a situation where you're asked to provide a forensic report and you tell a regulator no, and then they subpoena you, and now they're annoyed that you made them jump through this additional hoop. So we always recommend doing that. And then, of course, it's not going to be privileged, but then you have kind of the internal report with all the system names, recommendations, what happened, timelines, that is within your organization as well. We always say this, but keeping the need to know bubble as tight as possible, because all it takes is one employee to tweet something about it. And this is a true story. We had an incident where, I'm going to get into this a little bit about the OFAC sanctions process when you are considering paying a ransom, but there is a legal process you have to go through to make sure that a threat actor is not on the Treasury's kind of blacklist. And a employee that knew that that their company had been the victim of a breach, was not kind of in that need to know bubble, tweeted out, "It's Russia," which the FBI was like, that's funny. We're pausing all payments. We're pausing all negotiation. And the company actually was offline for several additional days because they couldn't get back up and they couldn't engage with a threat actor until they cleared this OFAC process, because one employee in a giant corporation made a stupid tweet, right? So, keeping that bubble kind of small, no speculation. Of course, I don't need to tell you this, but, label everything privileged confidential, include external counsel on everything, have external counsel really be kind of the commander of the incident and, setting up all the calls, kind of being on all the communications. That is going to go a long way, because courts don't like saying that this information is not discoverable. So these are just some of the basic tips that we typically always recommend. So a bit of just some takeaways on the regulator response aspect of this is the big one is they are going to take this as an opportunity to audit your organization's entire incident response posture. They're going to want to know everything from what firewalls you have to how long you retain data to where it's retained, how much money you spend and you allocate to cybersecurity. That's becoming a big concern. They want to know that you're allocating an appropriate percentage of your budget. And again, that's going to depend on a lot of factors in your organization. There's not kind of one black and white rule. But the regulators are getting really, really active in this space. It's a hot topic. They want to be more involved. More attorneys general that previously didn't really have a lot of experience in this space and a lot of interest in this space are, taking an advantage of being able to kind of step in. And again, they all talk to each other. They all have competing deadlines. So, we as the lawyers for our organization are kind of the front line of defense, right? We're going to be the ones on the phone with these regulators, also on the phone with our IT team, also getting asked for updates from the board or from the C-suite. So it is our job to make sure that we can appropriately liaise with all of the relevant stakeholders in our organization, or with our vendor that had the breach, or with our customers whose information might be involved, to make sure that this process all goes smoothly and we're not scrambling for this information at the end of the game, the week that the response is due. All right, so ransomware payment considerations. This is an aspect where we as attorneys also are becoming more involved in. It used to be that a lot of organizations would have bylaws or documentations that say any payment over X amount has to be approved by majority of the board of directors or unanimous approval, something like that. I will tell you, if your organization has something like this in your bylaws, change that as soon as possible, because I once had an incident where it required unanimous approval of the board to make a payment. One of their board members was on vacation, was not paying attention to his phone, had no idea that this was going on, and we could not pay this threat actor because we didn't have unanimous approval of the board, and it was what it was, and it was extremely frustrating. And the threat actor then, they didn't post a lot of information, but they start leaking your information on their dark websites, right? So there's a lot of things to consider. First of all, what can you do? So what does your bylaws say, articles of confederation, whatever it might be. OFAC is probably the most important consideration. So again, the Department of the Treasury has a list, it's called the Specially Designated Persons List, which is essentially a blacklist of nation states, individuals, organizations that you absolutely cannot pay. It does not matter if it is $1 or $1 million, you cannot make a payment to that threat actor. And that might mean that your systems are offline. It might mean that, it's unfortunate, but it doesn't happen often. But what you do is you also will typically engage a third-party forensic actor negotiation firm, threat actor negotiation firm. And what they do is, because when you get a ransom note, it'll say, contact us, here's our chat link. And they will pretend to be someone for your organization, pretend to be ignorant of what's going on. They have tactics to kind of draw out this process as long as possible. So we have time separately to figure out, what do we want to do? Are we going to make this payment? Do we need to make this payment? And they will run an OFAC check for you. Oftentimes, your bank might also do one as well. And so that is probably one of the biggest considerations to make prior to paying. Again, there are other considerations too. If you're a publicly traded company, do you need to report this on, periodic filings with the SEC, anything like that? So there are some legal considerations as well. Then it kind of goes into necessity, right? So do you need to negotiate with this threat actor? Are your systems operational or are they not? Do they have your data? So sometimes, they might say, they'll show you what we call proof of life, where they'll say, here's a sample of 5 files that we've stolen from you. And they might contain social security numbers or really sensitive information. And you're like, oh crap, this absolutely cannot be posted online. Like, we need to do something. Oftentimes what you'll do is you'll decide in that circumstance, you might want to pay the threat actor and you get that data back. So a lot of times they'll put it on a cloud repository. Mega is a really popular one. And what they'll do is they'll say, all right, it's on this repository, pay us X amount of dollars and we will give you the credentials to that. You change the credentials right away so then it can no longer access the data and you know exactly what they've taken. Sometimes they might not be able to show you proof of life. And based on the forensic evidence, you say, you know what? I think we actually stopped them before they stole this data. We don't think they actually have anything. And you might decide not to pay them. You might figure out that you can, depending on, this is kind of a risky approach and for reasons I can get into, but you can restore from backups or you have a decryptor. You don't need them to get your systems back to operation. There's a lot of strategy involved here. The FBI's official stance is not to engage with a threat actor. We usually do contact the FBI, let them know that this happened, and then we can share intel with them. So we'll give them the Bitcoin wallet, for example. We'll give them information. So, A, we can tell our customers and the individuals that we've been cooperating with the FBI, which they like to hear. But B, just kind of reinforces the fact that they do kind of, they won't officially sanction the payment, but they're on board. They know what's going on. And so, scope of data impact, reputational harm, you might figure out that the data is not actually sensitive from a legal standpoint. So if the threat actor posts this data, you don't have any legal obligations to notify, but if your customers find out, they're gonna get really frustrated, right? So it might not be personal information, it might not be business sensitive information, but you don't want your customers to see your invoices posted that has their name on it because, that's not gonna be a great look for your organization. So there's a lot of factors that go into this. We always counsel our clients that I'm sure you have an incident response plan of some sort to also have a ransom payment decision tree, right? So if, sometimes it might be financial, so we will not make any payment above 10 million, let's just say. We can negotiate that number down, but kind of those types of, decisions, right? Like if data is needed to restore our systems, then move on to consideration 2. If it's not, we're done. Consideration number 2. And it might depend on your organization, but we recommend that because this process doesn't always take as quickly as we expect. OFAC might take a little bit longer. Sometimes the threat actor doesn't respond right away. They're usually outside of the country, so there's always a time zone consideration there. So you want to know what your game plan is so you're not just delaying that time where you might be offline. You might not be able to operate. You might not be able to make payroll. That could open up another, plethora of legal obligations. So having this consideration tree ahead of time is going to make your life a lot easier when it comes down to making that decision. Because this is honestly what sticks, at least from a C-suite or a board perspective. This is what is going to be a big sticking point for them because you hear like negotiating with a threat actor. I'm not going to talk to a criminal. Why would I do that? And I just like to say also that we always get asked this. They say they gave us the data back. How do we know they're not going to reinfect us? How do we know they don't have a copy of this? And it sounds a little bit crazy, I will admit, but they do operate as a business and they depend upon a good reputation of being a criminal organization. Because again, when you have this third-party forensic, third-party negotiation firm, they'll say, this threat actor, they're not that trustworthy. They've been known to reinfect sometimes. Maybe you're not going to pay them because why would you? You might decide it's not worth it. Or they'll say, they're trustworthy as a criminal organization. They will give you your data back. They won't. We don't have problems with them reinfecting. They'll kind of leave you alone. So there's honor amongst thieves in some way, which sounds crazy to say, but we do find that when they say we've given you your data back or this is the extent of it, as long as you've engaged with them and you've paid them the agreed upon rate, they might step back a little bit. All right. So counsel's role, as if that wasn't crazy enough, what else do you have to think about when going through this really exciting process? So, all right. So again, it's really changed from being kind of the rubber privilege stamp on these documents and maybe, getting involved if there's litigation or, regulatory requests, something like that, to kind of being more involved in the proactive front, right? So you want to know, what data do you have? Where is it? What countries is it in? Who does it belong to? What are we doing to safeguard it? And is that enough, right? You are going to be the board's best friend and IT's worst enemy because you're going to be asking them for questions as they're trying to do their job. And again, they've got a lot of other stuff on their plate aside from just this incident response. So kind of being the middleman between that relationship and the relationship of the board or business leads that are kind of like, hey, what the heck, my customers are asking questions. Public and regulatory communications, depending on the size of the incident and the sensitivity of the data, sometimes we counsel our clients to engage third-party PR firms, and that's really when your customers' data is impacted and they're asking a lot of questions. You might have a lot of questions from regulators, and it's just really good to help take that off of your plate Again, because they're engaged by external counsel, all of those drafts are still going to be privileged, even if they are making public communications, which ultimately will not be. But all of the calls where you're making that decision, drafts, of course, will be protected by privilege, which is great. And just kind of one less thing for you to do, because again, you don't always want your business leads to kind of go out on their own and be communicating to your customers, because the investigation is changing every day. What's impacted changes every day. How far you are in remediation and getting back to operations is changing every day. So you really want to have a tight-knit group of the people that are responsible for those communications. And that's just one less thing that you have to do. Integrating cybersecurity into enterprise risk management. So really taking a look at, do you require your employees to take phishing training? And it's great if you do, but if they fail it, and you don't really do anything after that, is that really going to be beneficial? And regulators are going to ask you, even if the incident was not caused by phishing, it was no one person's fault, they're still going to want to see evidence that you provide training, and they're going to want to see how you document attendance lists, or what do you do if someone fails? If someone fails 3 times in a row, do they lose access privileges, things like that. And access controls, again, is a big one. So, does everyone in your entire HR department need to access employee tax information? Probably not. Do they have to have a different password for that system where that information is held? They probably should. And it used to be that we would leave that to our HR IT teams to kind of manage that. But we're going to be the front line when it comes to an incident, when it comes to the regulator response that follows. So if we can insert ourselves into that process now and make sure that, that's just one more proactive step that we're taking, that is something really important that we can do. Third-party risk management, again, is a huge one. It might not be your organization, but it can be a vendor of your organization that does your payroll or does your payment card processing or, manages your employees' health benefits, whatever it is. What sort of requirements do you put on those vendors? And, do you always want to have the strictest requirements, because do you want them to do that to you? So for example, we have clients that say, well, I'm going to revise all my vendor contracts so that they have to tell me within 24 hours if they have a breach. That might be great, but are you prepared to reciprocate that? And it's not always the case. And your vendors and the security that your vendors are able to provide on their end is going to be different. Like a global law firm probably has more resources to implement, what's reasonable safeguards for, a global company is going to be different than maybe a smaller mom and pop shop that you use for kind of one-off task. You know what I mean? So it's a big consideration of, do you audit your vendors? Do you ask them for any sort of security questionnaires? If you have litigation counsel, do you know how they're storing all that data? If you have, so we had an incident where it actually was a law firm breach, and this law firm they did a lot of Title IX for educational institutions, and they also represented hospitals, which, as you can imagine, are kind of 2 of the most sensitive topics of information that can possibly be out there in the world. And they pretty much had this information on a discovery platform for a long time and didn't move it over, and it wasn't encrypted. And that's how the threat actor got all this information. And as you can imagine, their clients were not very happy about that. So do you know what your firms are doing with that information? And, ask them, ask your payroll providers, know what they're doing and know how they're safeguarding it. Because at the end of the day, it might be their breach, but you're going to be the one that gets sued when that information comes out. So that type of third-party risk management aspect is super, super crucial. And that, again, is going to be, the lawyers are playing a front line in that relationship. All right, board and executive oversight. So regulators do want to see that your board or C-suite is involved. They don't want to know that, CEO is just out on his yacht and not really paying attention and doesn't know what's going on. So I think the last few times I've responded to HHS on their requests for information, they've asked, how do you report cybersecurity developments to your board? And that's not just a data breach. That is, do you report that, you had an audit that was really successful or that highlighted some vulnerabilities? Do they know what's going on? Because can they make the decisions to allocate appropriate resources, or are they just kind of not that interested? Because it always seems like the C-suite is more involved in the business than, and what they see is kind of like a behind the scenes aspect of the organization. But regulators do not let that fly anymore. So they're going to want to know that, are you updating your board? Do you present to your board or C-suite on cybersecurity issues? Do you send out even all personnel wide, updates on, hey, phishing incidents are really popular. Beware of these types of things, So that's another thing that we counsel our clients to do is, have these updates. This is how you do it. And that is super, super important. Again, touched on this before, but they want to know how much the percentage of your budget that you are allocating towards not only incident response, but just your information security posture. And they want to know about training for certain specialized roles. So that is, does your CISO have appropriate training? Or was this just kind of someone in your IT department that wasn't particularly senior and you just appointed them this title? Or are they really qualified for this role? And do they receive any other sort of annual training, right? So most regulators want to see that all of your personnel that have access to your network, whether it's on their own laptop or not, get some sort of annual, whether it's phishing training or like new hire onboarding, cyber training, something like that. But does your IT personnel, like your CISO, CIO, maybe some HR folks that touch really sensitive data, or depending on your industry, the folks that have access to kind of the holy grail of the data in your organization, do they have any additional training that's required? Do they have additional access controls? Like, do their passwords have to be changed any more frequently? Or do they have to have multiple passwords for different types of systems? Things like that. They're asking these questions. All right, so cyber readiness, these are just a couple of tips that we can do now within our organizations to hopefully make this process a little bit more painful. Again, the purpose of this is not necessarily to completely prevent a data breach from happening, although we would love to do that. But this is really focused on, it happened, let's move on, and we're going to make sure that the response is really smooth. So you want to have policies in place. You need to have an incident response plan that says, this is who you contact. And this sounds silly, but have a physical copy of that. And have a physical copy of your cyber insurance policy. Because if your systems are down and you cannot access your network and you don't know who your cyber insurer contact is, that's going to be a problem. Or you can't get to your incident response plan, so you don't actually know who to contact and how to get that ransom payment decision tree, all that stuff. Have physical copies of these things. It sounds silly because it's 2023, but it is one of the best pieces of advice I can give you. We like to do tabletops with our clients, so that is pretty much a simulated incident response process where we kind of sit around in a room like this and we show you a screen that says, all right, it is 9:01 on Monday morning and you log into your computer and it says, can't access. Who do you call? And your personnel is going to be sitting there like, I don't know. So we test that out. And so they know, all right, if this happens, this is what you do. This is what you do first. This is what you should not do. And kind of go over, depending on your organizations and what makes the most sense for you, just different scenarios so that when it does happen, people know what they're doing in real time and you're not scrambling and calling each other like, I don't know, I can't, what do I do? So mapping regulatory landscape, know who your regulators are. You can't choose your regulators, unfortunately. This is more of an impact in the healthcare space when you're like, is this HIPAA? Is this FTC? Some clients, for this could be a whole other presentation, prefer dealing with one regulator over the other for a variety of reasons. You want to know that ahead of time. You don't want to be scrambling thinking, do we have to contact the FTC or HHS or both or neither? What are we doing? So figure out ahead of time who regulates what data within your organization. If your organization is not already doing annual cyber pen tests or anything like that, they should, and you should be part of that process. You want to know what those results are so you can help your teams remediate it. So again, regulatory readiness assessments. Their rules are constantly changing. So for example, CPRA just came to effect in January 1st of this year. That has additional kind of reasonable security practices for California. The SEC has proposed rules that will require different types of what you have to disclose on periodic filing. So if you're a public traded company, that is definitely something to pay attention to. New York DFS, if you operate in New York at all, they have proposed rules too that are they also have a 72-hour reporting requirement, and they will require you to have certain safeguards as well in your organization. And that is it. And I'm sorry, I rushed towards the end because I know we're running out of time. But I do want to leave time for questions. I know we're short on time. I'll hang out a little bit if you have anything at all. But thank you guys so much. I hope you're not too terrified. Sorry if you have nightmares. I do too.